India Legal presents Courts Roundup.
Hello, I'm Misha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court expresses unhappiness over remission file of Rajiv Gandhi assassination convict being pending for 2 years before Governor. Madras High Court panel questions the Supreme Court order of establishing special court for trial of MPs and MLAs. Delhi government stops practice of affixing posters outside COVID patient homes, informed Delhi High Court. The Punjab and Haryana High Court declines parole to Sanji Ram, mastermind of Kathua gangrape, cites prosecution claim that release can trigger communal riots.
India Legal presents Courts Roundup.
The Supreme Court has orally expressed unhappiness over the fact that the recommendation made by Tamil Nadu state government for the remission of the sentence of AG Pirarivalan and the convict in the Rajiv Gandhi's assassination case has been pending before the governor for over 2 years. We do not want to exercise jurisdiction, but we are not happy with how this recommendation have been pending before the governor for 2 years, observed Justice L. Nageshwar Rao, the presiding judge of the bench. The Supreme Court has observed that it was not happy with how the recommendation of Tamil Nadu government for remission of the sentence of AG Pirarivalan, convict in the Rajiv Gandhi assassination case, has been pending with the governor for over 2 years. The bench of Justices L. Nageshwar Rao, Ajay Rastogi and Hemant Gupta asked Additional Advocate General for Tamil Nadu, Balaji Srinivasan, to find out why the governor has not decided on the recommendation of the state government. Srinivasan informed the court that the matter before Governor Banwari Lal Purohit was that of a larger conspiracy and that he was awaiting a report from the CBI. In response to this, the court said, "We don't want to exercise jurisdiction, but we are not happy with how the recommendation has been pending before the governor for 2 years." Appearing for the petitioner's senior advocate, Gopal Shankar Narayan contended that in the Nelofer Nisha case, related to the same remission notification, the court exercised its power under Article 142 of the Constitution to release the prisoners. Shankar Narayan further stated that grant of remission was the prerogative of the governor and is not under the Code of Criminal Procedure. The court has now asked the council to submit cases and points of law to show how the Supreme Court can give direction to the governor. Justice Rao referred to the 2014 judgment in the Shatrughan Chauhan case, wherein the Supreme Court held that mercy petitions have to be decided in a time-bound manner. He also cited a case where the governor had been asked to take decision concerning the assembly. Additional Solicitor General of India, K.N. Nataraj, told the court that the investigation on the angle of a larger conspiracy was spread over the United Kingdom and Sri Lanka, and that the Central Bureau of Investigation was waiting for replies to its latest rogatory. Justice Rao then asked, larger conspiracy probe is pending for 20 years and going. Still, you are at the stage of getting replies of rogatory letters from the UK, etc. Pirarivalan was awarded the death penalty in 1991 for his involvement in the conspiracy to assassinate then Prime Minister Rajiv Gandhi. He was charged for providing a 9-volt battery to co-conspirator Shiv Rasan for the explosive device used to kill Gandhi. After he spent 20 years on death row, the Supreme Court commuted Peralivalan death penalty to life imprisonment in February 2014. In September 2018, the government of Tamil Nadu announced its decision to release him along with 6 other convicts. And the Supreme Court has asked the Registrar General of Allahabad High Court to explain the alleged 6-month delay in an uploading of a judgment passed in November last year on the High Court's website. Notably, the case in question involves a question of irretrievable breakdown of marriage, which is not statutorily recognized as a ground for divorce, but which has been acknowledged by the Supreme Court in the past, including the last year. The bench of Justices Sanjay Kishan Kaul and Rishikesh Roy was told by the petitioner's counsel that while the judgment in his client's case was passed on November 6, 2019, the judgment copy was uploaded online on the court's website only in May this year. As such, the top court has now called for an explanation from the High Court's Registrar General for the inordinate delay within 3 weeks. The court proceeded to issue notice in the matter, which involves a matrimonial dispute. The petitioner has sought a decree of divorce on the ground of cruelty before a family court back in 2007, which was eventually dismissed on merit. The Allahabad High Court also dismissed an appeal filed against the family court order, agreeing with the family court that no cruelty was made out in the case for the grant of a decree of divorce. The High Court further noted that while the marriage may have been irretrievably broken down, it does not have the power to grant a divorce on this ground. Rather, the bench noted that this power was earlier exercised by the Supreme Court by exercising its jurisdiction under Article 142 of the Constitution of India. Upon the dismissal of the plea by the High Court, the petitioner has now approached the Supreme Court with his case. Taking note of submission that the spouses have been living apart for 13 years now and that the marriage has irretrievably broken down, the top court has issued notice in the matter returnable by 4 weeks and subject to the order passed in the application alleging inordinate delay in the uploading of the High Court's ruling online. And the Delhi government has told the Delhi High Court that it has passed orders to stop affixing posters outside the homes of persons under COVID-19 isolation. The Delhi High Court today also told the government to issue a circular instructing their district units not to reveal names and addresses of COVID-19 positive persons to anyone. The court was dealing with a petition seeking a direction to the Delhi government to protect the privacy of persons who test positive for COVID-19. Notice in the matter was issued by a bench of Justices Hema Kohli and Subramaniam Prasad in September this year. The PIL has been preferred by Advocate Kush Karla, and it was the petitioner's case that the practice of pasting or posters outside the houses of COVID-19 positive persons in home isolation leads to stigmatization and attracting unnecessary attention. Stating that such publicity is a serious infringement of the fundamental right to privacy, the petitioner had argued COVID-19 patients ought to be given privacy to cope with and recover from the illness in peaceful way from praying eyes. And the same petitioners had also approached the Supreme Court over the issue so that allied direction to protect the privacy of COVID-19 affected person could be issued to all states and union territories. And in anticipation of any litigation that it might get involved in following the ongoing dispute between Amazon and Reliance Future Coupons Limited, has filed a caveat in the Delhi High Court. The Kishore Biyani-owned entity, which runs Big Bazaar and other retail outlets, has prayed that no order of any kind be passed against in it petition or application that may be filed without issuing notice to it. The caveat has been filed through advocate Rishi Agarwal of Agarwal Laws Association and Associates. Future coupons appears to be caught in the crossfire of a battle between retail giants Reliance and Amazon, which recently obtained a favourable ruling before the emergency arbitrator at Singapore International Arbitration Centre in its fight to acquire the Future Group. Amazon has claimed that as per a deal in which it acquires 5% of Future coupons for 1,430 crore rupees in 2019, there is a negative list of 30 entities which Future Group cannot transact. One of the 30 entities was the Mukesh Dhirubhai Ambani Group of companies and the Ambani-owned Reliance Retail Ventures Limited, a subsidiary of Reliance Industries Limited, had acquired the retail and wholesale businesses and the logistic and warehousing business of Future Group in August this year. And the legal validity of establishing special court for trial of MPs and MLAs has been questioned by the Criminal Rules Committee, comprising of 3 judges from the Madras High Court. In a report dated October 13, 2020, the committee has stated that special court can only be offence-centric and not offender-centric. In other words, the committee condensed that courts can be constituted only by statute and cannot be constituted by the judicial or executive fiats. The remark on the panel were mentioned in a report submitted to senior advocate Vijay Hansaria, amicus curiae in the matter concerning expeditious disposal of criminal cases pending against former sitting legislators. In this case, a 3-judge bench of the Supreme Court, comprising of Justices N.V. Ramana and Suryakant and Rishikesh Roy, has asked the High Court to formulate an action plan to rationalize the disposal of criminal cases pending against legislators. The Madras High Court committee has, however, stated that constitution of offenders-centric courts is not legally permissible and cannot be a way to expedite disposal of cases. The committee noted that the Supreme Court fell in error by ordering that a central scheme may be prepared for setting up of courts exclusively to deal with criminal cases involving political persons with orders dated November 1, 2017 in Ashwini Kumar Upadhyay case. It is pointed out that the government orders creating special MP-MLA court trace their powers to this order and not to any statute. We are now joined by Advocate Shivam Sharma for more update on this.
Yes, in this case, the committee submitted that on MP-MLA who commits an offence under POSCO Act can only be tried by a special court created under the POSCO Act, and there cannot be another special court exclusively for trial of an MP-MLA who commits POSCO offence. The report further said that the Honorable Court was very guarded in its order, but unfortunately fell in error by creating special courts for trial of criminal cases involving MPs and MLA by implicitly adopting the format of the government order that was passed by the Telangana state. The committee has therefore sought an exemption from establishing any special court for trial of cases involving MPs and MLAs and has sought status quo in it. Yes.
Thank you, Shivam, for the update. The National Green Tribunal has issued notice to Ministry of Environment and Forest and 4 state governments on whether use of firecrackers from November 7 to 30th will be in the interest of public health and environment. The plea further stated that increased pollution may further affect the vulnerable groups and increase the fatality rate. The National Green Tribunal has sought the opinion of the Ministry of Environment and Forest, Central Pollution Control Board and other states on the issue of banning firecrackers from November 7 to 30th in a plea alleging that the increase in pollution may deteriorate the COVID-19 pandemic situation in Delhi. A bench comprising Chairperson Justice Adarsh K. Goyal, Justice Shiv Kumar Singh and Dr. Satyavan Singh Garbhyal and Dr. Nagin Nanda noted that there are also expert views on the clear nexus of air pollution with COVID-19. With increased air pollution, the virus can cause more damage. The application has been filed by Indian Social Responsibility Network through Santosh Gupta, referring to the statement of the Union Health Minister and the Health Minister of Delhi that during the festive season there will be a rise in COVID cases due to air pollution. The plea further stated that increased pollution may further affect the vulnerable groups and increase the fatality rate. COVID cases in Delhi may go up to 15,000 per day as against the current cases of about 5,000 per day. The use of green crackers will not remedy the situation. The smoke will choke and may create a gas chamber-like situation. It will lead to poor visibility, hazy condition and asphyxia. However, the bench referring to 2017 judgment of the Supreme Court in the case of Arjun Gopal versus Union of India noted that cases do not consider COVID-19 situation when the adverse effect may be of severe. That number of deaths of children, senior citizens and other vulnerable persons may increase. Number of diseases may also increase. This may result in respiratory, pulmonary diseases, diabetic, hypertension and other diseases. The bench has sought response from the Ministry of Environment and Forest, Delhi Police Commissioner, Government of Delhi, Haryana, Uttar Pradesh and Rajasthan on the question whether the use of firecrackers may be banned for the period from November 7 to 30th and has appointed senior advocate Raj Panjwani and advocate Shibhi Ghosh to assist the court as amicus curiae in the matter. The bench has listed the matter for further hearing on November 5th. Bureau Report. And the Punjab and Haryana High Court has declined to grant parole to Sanji Ram, who has been charged with masterminding the Kathua gang rape. The prosecution has claimed that Ram's release could raise communal tension in the area. Terming the concern raised as a genuine apprehension, the bench of Justices Dr. S. Muralidhar and Avnish Jingan stated, consequently, given the genuine apprehension expressed as regard to the possible law and order consequences if the petitioner's prayer for parole is granted, the court is not inclined to accept such prayer at this stage. Sanji Ram had moved the High Court seeking leave to visit his village for the wedding of his son. In 2018, Sanji Ram, along with Parvesh Kumar and a police officer, was sentenced for murder after raping an 8-year-old Bhakarwal girl, and she was held in a small village temple in Kathua district. After being raped, the child was bludgeoned to death. Ram was the caretaker of the temple where the 8-year-old Bhakarwal girl was raped. Pursuant to the Supreme Court order, the case was transferred to Punjab and from Pathankot to in Jammu and Kashmir. The Bakarwals are a pastoral community in Jammu and Kashmir. In proceeding before the Punjab and Haryana High Court, the senior police superintendent of crime branch in Jammu and Kashmir submitted a report to the court informing that the child's family had descended from the higher reaches to the village. If Ram were allowed to return to the village, there is every apprehension of there being community clashes and protests in Union territories of Jammu and Kashmir, the prosecution emphasized. Accepting the prosecution's stance, the petition for parole was dismissed. The Karnataka High Court has dismissed the bail application filed by Kannada actor Ragini Dwivedi and Sanjana Garani and others co-accused who were arrested by the police alleging for consuming and supplying drugs at parties and events they organize. A single bench of Justices Srinivas Harish Kumar dismissed the petition. A detailed order will be made available during the course of the day. The actors, along with others, have been charged under various sections of IPCs, including 120B Criminal Conspiracy and the Narcotics, Drugs and Psychotropic Substances Act of 1985 under Section 21, 21C, 27A, 27B and Section 29. Ragini was arrested on September 4th, while Sanjana was arrested on September 8th. Ragini was arrested on September 14th, while Sanji Ram was arrested on September 16. The special court had on September 28 rejected their application. The High Court, after hearing the application and the prosecution in detail, had on October 25 reserved its order. Mumbai Police has told the Bombay High Court that the complaint of Riya Chakrabarti against Sushant Singh's sister is disclosed commission of offence and certainly not bad in law as held by CBI. Mumbai Police has requested the Bombay High Court not to dismiss the case against his two sisters.
Days after the CBI opposed an FIR filed against Sushant Singh Rajput's sister on Riya Chakrabarti's complaint in the Bombay High Court, labelling it as vitiated and bad in law. The Mumbai police told the court the complaint disclosed commission of offence. In an affidavit filed in the court, the police said it was duty-bound to file the FIR first information report, dismissing the allegation that it was trying to damage the reputation of the 34-year-old actor found dead at his Bandra home in June or his sisters. The police submitted the affidavit in the court seeking dismissal of the petition filed by Sushant Rajput's sister Priyanka Singh and Meetu Singh to quash the case against them. The FIR was registered based on the information provided by the first informant Riya Chakrabarti, disclosing commission of offence. The affidavit read, stressing that a fake medical prescription was sent by the petitioner with the help of a Delhi-based doctor wherein medicines for anxiety were prescribed to Rajput. This may have led to administration of psychotropic substances without actual examination of Rajput by the doctor and may have caused and contributed in his suicidal death. This version of the information disclosed cognizable offences warranting investigation and requiring no preliminary inquiry. Therefore, the Mumbai police were duty-bound to register the FIR, the court was told. Last week, Riya Chakrabarti, facing multiple investigation over the death of actor Sushant Singh Rajput, had asked the Bombay High Court not to dismiss the case against his two sisters. Her complaint, she has said, it based on WhatsApp text between the actor and his sister on 8th June, 6 days before he was found dead. The chat indicated that Priyanka Singh had advised her brother to take 3 medicines, Librium, Maxito and Lonazep, which are prescribed for depression and anxiety. The chat, which surfaced in the media days before, indicated that contrary to their claim, his family was aware of his mental health problem. A day later, the CBI said the allegation by Riya Chakrabarti against the actor's sister are presumptive and speculative and could well have been part of the ongoing investigation. The Mumbai police, however, on Monday clarified in the court it's not trying to influence or derail the CBI probe. Bureau Report.
That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from Nation Around.
India Legal presents Courts Roundup.